Have you ever wondered what's really inside your personnel file? That folder HR keeps on you, filled with job applications, performance reviews, maybe even disciplinary notes? Many workers ask the same question. Do I have the right to see it? The answer depends on where you live and what laws apply. Unlike wages or overtime, there is no single federal law that guarantees every worker access to their personnel records. But many states have passed their own rules that give employees the right to review or request copies. Knowing your rights here can make a big difference, especially if you suspect your file contains errors, unfair write-ups, or missing documents that affect your job. In today's video, we'll break down when you can see your personnel file, how state laws differ, and what steps you can take if HR says no. Stick around. Part 1. What is a personnel file and why does it matter? A personnel file is essentially the official record your employer keeps about you. Think of it as a diary of your time at the company, but written and maintained by HR or management. It often contains your job application, resume, and references, tax forms like your W-4, records of promotions, raises, or disciplinary actions, performance evaluations, and attendance records, notes from supervisors or HR about your conduct or achievements. Why does this file matter? Because decisions about your job, whether you're eligible for promotion, whether you've been warned properly before termination, even whether you qualify for unemployment benefits, may be influenced by what's inside. If there are mistakes in that file, you may suffer unfair consequences. For example, imagine you were wrongly marked absent without excuse when you actually had doctor's notes on file. Or maybe a supervisor wrote a negative evaluation that you never saw. Without reviewing your file, you wouldn't even know these entries existed, let alone be able to challenge them. Here's the tricky part. There is no federal law that guarantees every U.S. worker the right to see their personnel file. Federal laws like the Fair Labor Standards Act, or Title VII, cover pay, overtime, and discrimination, but they don't require file access. Instead, it's up to each state to decide. That means whether you can see your file depends heavily on where you live. In some states, you have a clear right to inspect and even get copies. In others, it's completely at the employer's discretion. This patchwork system can be confusing, but it also means you might have more rights than you think if you know your state's rules. So the first step is understanding the legal landscape. No nationwide guarantee, but many state-level protections. And in states that don't have explicit laws, sometimes company policy fills the gap. Part 2. State laws that give employees access. Since there's no single federal law covering personnel files, the answer to this question comes down to state law. And here's the good news. A majority of U.S. states have passed rules that give employees the right to view or request copies of their personnel records. For example, California has one of the clearest laws. Under California Labor Code Section 1198.5, both current and former employees have the right to inspect or obtain a copy of the personnel records that relate to their performance or any grievance concerning them. Employers must provide access within 30 days of a written request. That means if you write HR asking to see your file, they can't just ignore you. They have a legal duty to respond. In Massachusetts, state law gives employees the right to review their personnel record up to 2 times per year. Employers must also notify employees within 10 days if negative information, like a written warning or performance evaluation, is added to the file. This ensures workers aren't blindsided by hidden documents. Illinois has the Personnel Record Review Act, which allows employees to inspect their personnel records at least twice per year. Employers must make the records available within 7 working days of a request. Employees can even request copies, although employers may charge a small fee for duplication. Minnesota and Michigan also provide clear rights. In Michigan, the Bullard-Plawecki Employee Right to Know Act lets employees review their personnel files once every 6 months. It also gives workers the ability to add a written response to any disputed item, which then becomes part of the file. Not every state is this explicit, but many have similar rules. Some limit access to current employees, while others extend rights to former employees as well. A few states, like Florida and Texas, don't have statewide laws granting access, leaving it up to employer policy. It's also worth noting that public employees, those working for government agencies, often have more access rights than private sector workers. This is because public records laws sometimes make personnel files available under open records or freedom of information statutes, although sensitive information may be redacted. The bottom line is that in many states, the law is on your side. If you want to see your personnel file, you usually have the right to submit a written request, and your employer must allow inspection within a set time frame. Knowing your state's specific rule is the first step in protecting yourself. Part 3. States without guaranteed access and employer discretion. While many states have strong laws giving employees the right to review their personnel files, several states do not. In these places, whether you get access depends largely on company policy or the goodwill of your employer. Take Florida as an example. Florida has no general state law that requires private sector employers to let workers see their personnel files. If you're a teacher, police officer, or another public employee, you may have access under the state's public records law, but if you work for a private company, the decision is entirely up to your employer. The same goes for Texas. Private sector employees there don't have a legal right to review their records. Some companies voluntarily allow access as a matter of transparency or good HR practice, but others may refuse. In those cases, unless you have a union contract or some form of written agreement, you're out of luck. Other states with limited or no statutory rights include Georgia, Missouri, and Mississippi. In those states, if your employer denies your request, you can't force them through state law. However, company handbooks or HR policies sometimes grant employees inspection rights, and those internal rules can carry weight. If your handbook says employees may review their personnel records upon request, that statement can be treated like a binding promise. It's also worth pointing out that some states provide partial rights. For example, in New Jersey, there is no law requiring access to personnel files for private employees, but public workers may be able to request access under open records laws. In Ohio, the same general rule applies. Public employees often have more rights than those in the private sector. So, what does this mean for workers in states without guaranteed access? It means you should start by checking your company's written policies. Many employers include a section in their handbook about personnel files, often stating whether employees can inspect or obtain copies. If the policy grants access, you can usually hold the company to that standard. If no policy exists, your best strategy is to make a respectful written request. Even in states without a law, some employers will provide access voluntarily to build trust and avoid disputes. After all, transparency is often in everyone's best interest. The key takeaway here is that your rights vary dramatically by location. In some states, it's a legal guarantee. In others, it's at the employer's discretion. Knowing which category your state falls into will help you set realistic expectations when you ask to see your file. Part 4. How to request your personnel file and legal limits. So, let's say you've learned that your state gives employees the right to review their personnel files, or maybe your company has a policy that allows it. How do you actually make that request, and what should you expect? The first step is usually to submit a written request. Many state laws, like California's Labor Code, Section 1198.5, or Illinois' Personnel Record Review Act, require employees to make the request in writing. An email or a formal letter to HR is often enough. Be clear in your wording. For example, I am requesting to inspect or obtain a copy of my personnel file pursuant to state law. If you're in a state without a law, you can still politely request access under company policy. Most states that grant this right also require employers to respond within a specific time frame. In California, the deadline is 30 days. In Illinois, it's 7 business days with a possible extension. In Massachusetts, access must be provided within a reasonable period, usually 5 business days. If the employer ignores your request, that may itself be a violation of the law. When you do get access, it's important to understand what's included and what isn't. State laws often define personnel records as documents related to your qualifications, performance, discipline, or compensation. That means you'll usually see job applications, evaluations, warnings, attendance records, and payroll information. However, there are legal limits on what you can see. Many states allow employers to withhold certain documents, such as confidential references from previous employers, information prepared for lawsuits or internal investigations, medical records, which are often kept in a separate, confidential file under privacy laws like HIPAA, documents relating to other employees which could violate their privacy. For example, under Massachusetts law, if your supervisor wrote a private note for HR that wasn't used in a formal evaluation or disciplinary action, it may not count as part of your personnel record. Similarly, in California, some categories of documents are exempt, including records of criminal investigations. If you discover errors in your file, some states allow you to submit a written statement of disagreement. In Michigan, under the Bullard-Plawecki Act, that statement must be attached to the disputed item and remain in your file. This way, if the file is ever reviewed for a job decision, your side of the story is included. So the process comes down to 3 steps. Submit a written request, review what's provided, and if needed, challenge inaccurate or incomplete entries. It's not always perfect, but it can make a real difference if your job or reputation is on the line. Part 5. Why access matters, real-world scenarios, and lessons for workers. Now, let's talk about the bigger picture. Why it actually matters to see your personnel file. For many workers, the personnel record feels like a locked box controlled by HR. But the truth is, what's inside can directly impact your career, your reputation, and even your ability to challenge an unfair firing. Think about performance reviews. If your file includes inaccurate evaluations or disciplinary notes you never saw, those documents could be used to justify denying you a promotion or even terminating your employment. By reviewing your file, you get the chance to spot those errors early and, in some states, attach your own written response. That means your side of the story becomes part of the official record. Here's a real scenario. A worker in Illinois was denied unemployment benefits because her employer's file claimed she had been fired for misconduct. But when she reviewed her personnel file under the state's Personnel Record Review Act, she discovered no written warnings or documented misconduct. With that evidence, she successfully appealed and received her benefits. Access to the file made the difference. Another case involved a California employee who suspected she had been passed over for a promotion due to bias. By requesting her personnel file under Labor Code Section 1198.5, she found performance evaluations that praised her work, contradicting the employer's claim that she lacked leadership skills. That file became key evidence in her discrimination claim. It's also important for job hunting. If you're applying to new positions and your former employer is contacted for a reference, what's in your file could shape what they say. In states where you can review your file after leaving a job, it's smart to do so before moving on, so you know exactly what might be shared. For unionized workers, access helps ensure fairness in the grievance process. If the employer claims progressive discipline was followed, the personnel file should show those steps. If it doesn't, the union can argue that the firing violated the contract. At the end of the day, having the right to see your personnel file is about transparency and accountability. Employers hold a lot of power, And without access, employees are left in the dark about records that affect their livelihoods. Knowing your rights under state law and exercising them when needed gives you the ability to correct mistakes, challenge unfair treatment, and protect your career. That's why this right, where it exists, is one of the most practical tools for workers who want to stand on equal ground with their employers. So, do you have the right to see your personnel file? The short answer is, it depends on your state. There's no single federal law that guarantees access, but many states, including California, Illinois, Massachusetts, and Michigan, do give employees clear rights to inspect and copy their files. In other states, it may depend on company policy, union contracts, or whether you're a public employee. Why does this matter? Because your personnel file can shape everything from promotions to unemployment benefits. Errors in that file can hurt you, but reviewing it gives you the chance to correct mistakes and protect your record. If you found this breakdown helpful, hit like, share it with a coworker, and don't forget to subscribe for more plain English explanations of workplace rights. And if you've ever tried to request your personnel file, tell me in the comments what happened. Remember, knowledge is power, especially when it comes to your job